story of the day, the Maharashtra political crisis reached the Supreme Court as the rebel Shiv Sena MLAs continue to camp in Guwahati. In a breather for the rebel Eknath Shinde camp, the top court put on hold the disqualification proceedings against 16 rebel MLAs till 11 July. The next hearing is also on the same date. The top court has asked the Uddhav camp to reply to a petition of the rebel MLAs that challenged the Deputy Speaker's competence to issue disqualification notice of MLAs, even when the rebels had moved a motion seeking his removal. The court has also directed Maharashtra Deputy Speaker and the Legislative Office to file a comprehensive affidavit on whether the notice of motion for removing the Deputy Speaker was received and why it was rejected. Now, rebel MLAs have 2 weeks to reply to the disqualification notice. Let me go across to my colleague Meenakshi for the details of what happened in court today.
Well, the Supreme Court is keeping the matter pending with itself. That's the big news. The court has given a next date of hearing, which is the 11th of July, when the matter has been posted for a next date of hearing. And like you rightly mentioned, the court has issued notices on the pleas of the rebel Shiv Sena MLAs challenging the disqualification proceedings initiated against them. And not just that, the Supreme Court, like you rightly mentioned, has asked the Maharashtra Deputy Speaker and the Legislative Office to file an affidavit on whether the notice of motion for removal of Speaker was received and why it was rejected. So that response also has been sought by the Supreme Court. A comprehensive affidavit has been sought by the top court. Now, the issue at stake here is quite multifarious. But the primary issue here has been what has been put out by the counsels on both sides. Senior advocate Mr. Neeraj Kishan Kaul, representing the case of the rebel MLAs, saying that the Deputy Speaker and his role itself is under the scanner, and therefore he is not the authority to adjudicate on the disqualification pleas now of these MLAs. And then he went on to allege as to how purportedly a lot of undue haste has been shown by him to seek responses of these MLAs in a very limited period of time, instead of giving them a mandatory period of 7 days to file their responses, to which we heard before the Honorable Supreme Court Dr. Abhishek Manu Singhvi say as to how these are all discretionary powers which the Speaker is entitled to as per the constitutional provisions, and the Supreme Court really cannot be dealing or getting involved in the proceedings of the House.
All right, Mr. PDT Acharya, former Secretary General of the Lok Sabha, is joining us now on the show. He's one of our foremost constitutional experts. Mr. Acharya, good evening, and thank you for speaking with us on the India development debate. Sir, can you explain to us where today's Supreme Court's order leaves us in terms of the next moves? We'll keep the political stalemate to one side because one camp is in Guwahati, one is in Mumbai, and both are claiming that they're the real Shiv Sena. But what does this mean for the government? Is the government of Maharashtra today officially in a minority?
See, that question will be decided on the floor of the House. The question whether the government is in a minority or not. Now, what the Supreme Court has done is to give a little more time to the dissident MLAs to file their replies. In fact, so far as the time that is to be given to the MLAs against whom proceedings are to be initiated, the rule says that 7 days time will be given to them, 7 days. And if the MLAs ask for more time, then it is the discretion of the Speaker to extend the time further. But 7 days period is the maximum. I mean, it's the mandatory period. But here the Supreme Court has given much more than that. Now, the question is, under the rules, it is actually the Speaker or the Deputy Speaker in this case who gives time or who extends the time. Both these things are done by the Speaker only under the rules. And at this stage of the proceedings of the disqualification proceedings, the outside authorities do not come in the picture. In fact, court gets jurisdiction only after the Speaker has taken a decision on the merit of the case, not before that. In fact, this has been made clear by the Supreme Court in a number of cases earlier. So the court's jurisdiction starts only after the Speaker has taken a final a decision on the merit. Now that stage has not come. Here what has happened is the notices have been, the petition has been filed and the notices have been sent to the members. So it is there that the court has intervened and extended the time. So that is what actually has happened. Now, the question is what the government is going to do. Well, that is a matter which should be decided by the government. There are many possibilities. If the government feels that it has lost majority, then it can resign, or the governor feels that the government doesn't have majority. In that case, the governor can ask the Chief Minister to take a floor test, prove his majority. In that case, the assembly will meet and then motion will come, voting will take place,
Right.
and all that. You know, these are all things which usually happens.
No, so just a couple of things I want to understand, sir. This legal sort of move by the rebel camp, because they moved for disqualification of the Deputy Speaker before he's returned any decision on their expulsion or on their disqualification. And now they have gone to court saying that he can't decide on us because we've asked for his disqualification. Now, is this a legal loophole and will this stand the scrutiny of court?
Actually, you know, the constitutional bench of the Supreme Court had said, I think it was in 2016, I think the Navam Rabia case, that a speaker against whom a no confidence motion is pending cannot decide disqualification issues. So that was the decision of the Supreme Court. Here they are citing that decision. But there is a difference in this. Here, you know, the no confidence notice against the Deputy Speaker has been sent by email, and there, as I understand, this was sent from some private email or something, where the Deputy Speaker and the office of the Deputy Speaker is not very clear about the authenticity of this particular document, and therefore it has not been admitted. Now, you must know that when a no confidence motion notice is given, it needs to be admitted first, and then it goes to the House as a motion, and then the House finally takes a decision. So far as no confidence matter is concerned, that has to be decided by the House only, not by the Speaker or Deputy Speaker. What the Deputy Speaker will decide is the admissibility of this. And the Deputy Speaker is well within his right to decide the admissibility, because the rules empower him to decide the admissibility of the notice. That is the point. So there, to say that he is a judge in his own cause, perhaps is not correct, because he is not deciding on the merit of the issue. He will decide only the admissibility of the notice in terms of the rules, I think.
Just a question on the rebel MLAs. Now, they in number outnumber the elected MLAs who are with Uddhav Thackeray. So, does that give credence to their claim that they are the Shiv Sena? What defines the party? Is it the number of elected MLAs and which camp they are in, and then what are the options for them ahead?
See, this question needs to be decided by the Election Commission. So they have to go before the Election Commission, and only the Election Commission will sort it out. Election Commission will naturally go into all these factors. There are the number of MLAs with them, the number of MPs with either faction, or the whole party. After all, the party, there is a structure, and in that party, how much support each faction enjoys, and all that. These are the basic things, you know, which will be considered by the Election Commission to decide which faction is the real party, Shiv Sena in this case. That will certainly take some time, because the Election Commission has to go through the evidence and all that. So that is that is going to take a little time. So that can be, in any case, you know, that can be decided only by the Election Commission. Here, so far as the government is concerned, you know, its fate can be decided by, on the floor of the House. Whenever they take a floor test.
Thank you so much, Mr. Acharya, for joining us and putting into perspective this fight to reach its logical conclusion has quite some time to go. Just one last point, sir. So, does the government, if Uddhav Thackeray as Chief Minister currently wants to call for a floor test, does he have to wait for the 11th of July or can he do that at any point?
At any point he can do that because there is no bar on that. Supreme Court has not put any bar on that. So any time it can be done.
They can call for a floor test anytime.
Yeah.
Oh, what are they waiting for?
Yes.
Is the question. If both sides claim they're the real Shiv Sena and have the numbers, then what are they waiting for? Well yes, sir.
Well, that is a $1 million question. But that's a political question that needs to be decided by them only.
Exactly. That's where the real politics comes in. Thank you so much, Mr. Acharya, for joining us today and breaking down where the logical conclusion of this political fight will be.